In this session, I am going to talk about the good faith deposit or the earnest money deposit or EMD. Why? Because money talks. But what is it saying? We need to have an understanding of the 6 W's: the who, the what, the where, the when, and the why, and maybe even the why not. Because it is money and people get worried and very particular about how it is being used or not used. From the number of questions that we get through the years, what seems like a simple subject is actually anything but simple, and it is important enough to get its own little video. So here are some of the questions that are asked. Can we get our money back? When can we get it back? What happens to the money if the buyer backs out? Can the seller keep my deposit? Is the earnest money deposit refundable? Who holds the deposit? This is Juliana too. You get the gist of this. It is an important subject. But before we get into it, be sure that after the video, you check my informational links in the video description below. First of all, let's go through the disclaimer. The information contained in this video is only intended to provide a guide in the various transactions to which the information is applicable. No representation is made as to the legal validity of the information or the adequacy of it in any specific transaction. The information contained should only be used after consultation with legal and financial counsel. And this is a very important sentence. After consultation with your legal and financial counsel, because it is about money. Okay, so what is the who? In real estate language, the earnest money deposit or EMD is also called the good faith deposit in escrow language. So the who is very easily answered. This is the monetary deposit that a buyer puts down as a good faith to show their serious intention of buying the seller's asset, whether it is a property or a business or even a personal asset like a car. So you are actually putting the money where your mouth is, so to speak, finalizing the contract. But it is usually given subject to a few conditions, like getting the property with clean title ownership or getting a new loan to supplement the balance of the purchase price. What is the easiest way to get the EMD? The easiest way, of course, is always a check or a cashier's check. But the best way is through wired funds, because wired funds means that the funds are immediately available and do not require any time to clear the bank. Now, escrow agents are governed very strictly when it comes to taking in cash. So if you have cash, you should go to the bank first and convert it to a bank check. What about other assets instead of cash equivalency to be used as collateral for this transaction? The pink slip of a car, for instance, or certificates handed over for certain stocks. The valuation of these types of assets change on a day-to-day basis. So unless there is a monetary value established at the opening of the escrow, and the escrow agent can actually hold the assets in their office, this type of good faith deposit is really not recommended. What happens if if there's complications to the transaction and it falls through? So again, having a cashier's check, a check, or bank wire is going to be your best friend, and that is why it's always called an earnest money deposit. Now, the EMD good faith deposit is usually given to the escrow agent who holds it in trust, as we are the neutral third party chosen by the buyer and seller. The escrow agent is a depository of all the funds and documents. They make sure that the parties fulfill their contract, and when done, then transfers and exchanges the funds and documents to the final parties. Check out our links in the description below of what is an escrow and the role of the escrow holder. Now, funds are usually deposited in a federal or state insured bank account. This is according to each state's laws and regulations. This is what we call a trust account in escrow language. And the parties may think otherwise, but the transaction, as it is running through its course, the EMD belongs neither to the buyer or the seller. It is now in neutral hands. And this is important because later on we're going to talk about what happens when either party does not perform the contract and the escrow cancels. The EMD is a symbol of the buyer's intent to purchase and proceed with the transaction. So once the buyer has made an offer, the MD usually follows immediately. Once the offer is accepted by the seller, the check and the offer is handed to the escrow agent, and then we consider this transaction formally opened. There are times when the buyer gives the EMD directly to the seller's account, but that is pretty rare because unless the buyer and the seller have a mutually trusting relationship, then it doesn't happen. What if the transaction cancels? The buyer may not be able to get the money back if the EMD was already given to the seller and he has already cashed it. Usually the parties are unknown to each other, and so therefore they require this third party to become the middleman. No matter who gets the money, the when is usually when the transaction is opened or very shortly thereafter. Now, why? The handing over, excuse me, of an EMD is considered a commitment to purchase and sell by both parties. Let's say that you are the seller with a very valuable asset to sell, and there are a number of parties who want to buy. Who do you sell to? At what price? After the final sales price is negotiated, the buyer will want a commitment from the seller that he will be held to that price. And as to the seller, this shows a sincerity in his offer, an acknowledgement that he will not take on any other offers at a higher price. So the EMD is a commitment by the seller to sell at a negotiated price to the buyer, and it is a commitment by the buyer to purchase so that the seller will give up any other offers, even if it is at a higher price. So basically, it is an inducement for everyone to honor the buyer a willingness to purchase, and that he is making a good faith deposit, and that's why it's called a good faith deposit. Now, is there a why not? Is there a time when the EMD is not necessary? And yes, that may be the time when the two parties are actually have an implicit trust in each other that the transaction will be followed through to the final closing. For instance, a sale between relatives. Does there have to be an EMD? No, there is no law that says that there has to be an initial good faith deposit to secure a contract. Now, we have finished with all the W's, and let's go and discuss how much. As I mentioned before, there is no law that states there has to be an initial deposit. So therefore, there is no law to say how much this good faith deposit has to be. So it's dependent on three things. The first one, it is a negotiation between the parties. The second one, it could be based on customary practice in the area. For instance, in some areas of the country, it could be $1,000. In other areas of the country, it could be 3% of the sales price. Also, it can be based on what type of transaction it is. For a transaction of a real property, it tends to be higher because the value is higher. For a transaction of a business, it can be lower. Of course, the buyer would like to put in less money in case a transaction does not happen, and the seller wants the buyer to put in more because they want to be sure that the buyer is going to perform. So it's a matter of negotiations, and of course, of what the market will bear. Now, here are some questions that have come up through the course. What happens to the EMD through the transaction? As the good faith deposit is the buyer's guarantee that he will perform, there are always strings attached to it. And these strings are normally called contingencies or conditions to the transaction. So once the contingencies or the conditions are met, the transaction moves forward and the EMD then becomes a part of the down payment for the sales price. If, for instance, the contingencies cannot be satisfied, then of course, normally the contract is canceled and the return of the EMD to the buyer is then given. Can the EMD be used to pay bills before the transaction is finalized? The funds are held in trust. And once deposited, it will belong to neither the seller nor the buyer. Any disposition of it or partial disposition of it will require the consent of all the parties. For instance, let's say that there's a homeowners association and they require an upfront fee to release documents to the buyer for review. We ask the seller to advance the funds instead of course, using it from the EMD. Let's say the seller says he cannot and he wants it to be taken out of the EMD. The escrow agent at that time will have to draw up an amendment for all parties to agree to use the funds to pay. What if the transaction cancels? And this is always that important question. Will the buyer get his full EMD back? The cancellation of a contract is always tricky. Getting the EMD back depends, first of all, on how far the transaction has gone and why it is canceling. If it is canceling because of conditions that could not be fulfilled for some reason, like for instance, the buyer could not qualify for the loan or there was a problem with the seller's title, then of course, usually the seller will agree to refund the deposit in full to the buyer. However, if the conditions of the transaction have been satisfied and the transaction is almost halfway done or close to the end, then of course, the seller may disagree to give the buyer his full deposit back. Again, transactions can be tricky. If there's a negotiation that is necessary, then there is a possibility, of course, that legal counsel will be brought in to get the parties involved. The thing to remember is, no matter what, as the neutral third party, there is no release of funds until a mutually signed cancellation agreed upon between parties have been sent to the escrow holder. Because both parties may feel that they have a claim to the transaction. I had one file in which I had funds held for 5 years because there was no resolution. My file had canceled. The property was long sold to somebody else, but nobody could agree on how to resolve the matter of the money that was still held in escrow. If there is a cancellation, will there be fees to be paid and deducted from the top of the EMD? There are different scenarios involving contract cancellations. Most of them are unhappy events, and some involve attorneys and money and time is spent. So yes, there is a possibility that the fees that have been incurred will need to be paid, especially if a lot of work has been done and the transaction is at its final stages. For instance, the escrow agent's service fee, fees for certain reports, or reimbursement for fees that have been paid. Who pays those fees will depend on what the parties negotiate. It can be deducted from the buyer's EMD if the buyer is willing to pay for those costs, or it can be paid by the seller, who will then bring in a check to the escrow agent to pay for those fees. Now, my t-shirt for the day. As you can see, I'm the oldest child. In my family, I have a brother and I have a sister. I'm the oldest child. And I have told them forever and ever that because I'm the oldest child, I make the rules. So we had a t shirt made for each of us. And one says that I'm the middle child, doesn't follow the rules. And the youngest child says that the rules do not apply to them. This is Juliana too, and I certainly hope that you have gotten some information from my video. There are other articles in the video description below. I hope that you will click the like and the subscribe buttons, and thank you for watching. I shall see you in my next video.